much for the warm welcome, and thank you so much for the organizers for another fantastic conference in this incredibly beautiful city. So, ladies and gentlemen, dear colleagues, dear esteemed guests, allow me to start my presentation, The Best Interest of the Intended Child. And I wanted to start by mentioning that as we stand at the crossroads of innovation and technological development and are navigating through the complex terrain of assisted reproduction and surrogacy and all of these significant developments, there are many issues that we have to address, I think, with urgency. Europe, like much of the developed world, is facing demographic challenges, the aging of the population, declining birth rates, although, as we mentioned, based on our research in the Professors Network, we can see that there is some reason for hope. In Central and Eastern European countries, we can see some positive improvements as well. But in general, the developing world is definitely facing demographic challenges. And in many circles, assisted reproductive technologies are being viewed as kind of a beacon of hope or a potential solution for these demographic challenges. Because these technologies promise not just a continuation of families, but also the sustenance of society in the views of many. But I think in this rapidly evolving landscape, we have to stop and pause for a second and kind of think, at what point do we stop to consider the rights of the most silent stakeholders in all of this, the children? So when I talk about the purpose of family law to my students at the university, I always mention to them that the child is at the focal point of family law and, of course, child rights protection. So it is clear, I think, how our views have shifted when we look through many scientific articles. When we look at adoption, for example, the primary goal of adoption should not be providing childless couples with a child, but it should be the opposite, providing the child with a family. And I think the same goes for these technologies as well. We need to view it from the best interest principle of the child. So the pursuit of ART and surrogacy is also driven by a desire to create families and to fulfill dreams of parenthood, but it also brings forth a lot of issues, a plethora of legal, ethical, and societal questions. And it is within this context that we have to stop and reflect, are we adequately considering the rights of the children born through these technologies? So the best interest of the child, a principle enshrined in the United Nations Convention on the Rights of the Child, mandates that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, or administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. So as we explore the legal frameworks regarding ART and surrogacy, I think that needs to be our guiding principle as well, the rights and the welfare of the children involved. Because these children born into the world at the forefront of reproductive technology deserve no less than our utmost commitment to safeguarding their rights and ensuring their well-being and upholding their dignity. So today I invite you to embark on a critical view on ART regulations and challenge some preconceived assumptions and question established norms regarding ART, and to forge a place forward that places the best interest of the child, of the intended child, at the heart of our discussions on assisted reproduction and technology. Now, of course, there are many issues that I could speak about, and Alexandra, I think, set the stage very well. So that's part of the issues when we talk about the right to know one's own heritage. So I'm not going to address that because we already heard a presentation on that. But another legal challenge, of course, is the protection of the health and the welfare of the child that we are going to address today. today, and then many ethical and moral considerations that we also heard in the questions pop up today, questions on the commodification of the child, issues on the exploitation on surrogacy, potential sale of the child or trafficking. So all of these questions I think are very significant. So when it comes to the history of ART, again, we already had an excursion, so I'm not going to spend a lot of time here because Alexander started back in the 15th century. I would say that when we look at surrogacy, we could even go back further to biblical times because, Abraham and his wife Sarah used Hagar, a handmaiden, to conceive a child that was intended for them. So that's the first case of surrogacy. And then, of course, throughout history, the question of how to, help couples conceive a child where there are issues, of course, have always fascinated humanity. But the first instance of a recorded and proven records of artificial insemination was in the 19th century by J. Marion Sims, a physician, who conducted 55 postcoital inseminations using very highly controversial methods. He used slaves without their consent and without anesthesia, and only one of these inseminations resulted in a pregnancy which ended with a miscarriage. Part of the reasons why there was such a low success rate is because he believed that the fertile days of a woman is during her menstruation, so that ovulation occurred during menstruation, so that's why the success rate was very low. However, very shortly after that, we have successful artificial insemination that ended with the birth of a child, which happened in 1884. Again, a physician, William Pancoast, was involved. Again, very much highly controversial methods were linked to this experiment because in this case it was a lady who, again, without her knowledge or consent, was subjected to artificial insemination. It happened during anesthesia, and essentially what happened is she gave birth to a healthy baby 9 months later. Of course, the ethical and moral background of these first experiments are very highly questionable, but nevertheless, they led to the medical marvel that is artificial reproduction. And then, of course, in the 20th century, we see the evolution gradually towards in vitro fertilization technology, which made it possible in the 1970s that fertilization could occur outside of the human body. And essentially, this breakthrough was concluded in 1978 with the birth of the first IVF baby, a moment that signaled a new era in reproductive medicine and fertility treatments. Now, of course, there have been other significant milestones that I think are important to mention. Cryopreservation methods that were developed in the 1950s. That was at the first time it was only just cells, mammal cells, that were able to cryopreserve. But this process essentially allows for the freezing of human cells and then later human organs and then later potentially even humans as well. But cryopreservation essentially broadened the scope of artificial reproductive technologies and made things like sperm donation or egg donation or embryo storage possible. And then, of course, another very significant step in the history of artificial reproductive technologies is genetic screening techniques. There are many different genetic screening techniques, but the techniques that are used in artificial reproductive technology are most often pre-implantation genetic diagnosis and pre-implantation genetic screening. Of course, not all genetic screening techniques are linked to artificial reproductive technologies, but they are used also outside of that. And of course, they raise a plethora of other ethical and moral questions. So when we talk about the best interest of the child and the best interest of the child, specifically in ART, I have to mention that this principle occupies a central place in international and national legal systems as well, concerning family law and child welfare. This principle, while universally recognized, is subject to a broad range of interpretations, reflecting, of course, our legal, cultural, heritage, societal context. So, depending on where we are from, we view the best interest of the child differently. And also, I think there's a case-by-case basis as well. So the best interest of the child principle at its core mandates that all decisions impacting a child must prioritize the child's well-being and safety and holistic development. But the interpretations, of course, can vary significantly. Now, the principle itself was legally enshrined in the UNCRC, very famously in its Article 3. But besides Article 3, I would also highlight Article 18, which highlights the responsibility of the parents. So this principle not only guides institutional and legal processes, but also underscores the parental role in fostering and safeguarding the welfare and development of children and having the best interest of the child in the forefront of all of these decisions. Now, of course, I have to mention especially since we are in Poland, the Polish initiative in the UNCRC and how the text was drafted and how originally the question of the conceived child was also discussed. However, as a compromise solution, later on, this was left unanswered in the text. So the text does not address the beginning of life. It only addresses the end of childhood as the 18 years of age. However, does not address the beginning of life, which essentially was a compromise solution, but because it leads to a flexible interpretation, it kind of allowed for the UNCRC to become the most widely ratified convention of the world. Now, of course, when we apply the best interest of the child principle, it is not without its challenges, because one of the main difficulties lies in its subjective nature, because what is the best interest of one child may not be the best interest of the other child. So, of course, we have to view each situation case by case. There are so many different issues that we have to consider when it comes to ART, when it comes to adoptions, when it comes to anything involving the child, their cultural heritage, their national identity, their mental health, their physical well-being, and so many other things. So I think it's a very nuanced issue. Now, of course, when it comes to the application of the best interest principle on the intended child, we have to stop here for a moment, because, as I mentioned, the UNCRC does not talk about the conceived child, but when we talk about the best interest of the intended child, we are talking about even a step before that. We are talking about the potential future child, so a child even before conception. So the critical question arises regarding the application of this best interest principle to potential future children, because the principle is traditionally meant for children who exist, right? And not for making determinations about whether allowing conception would be in the best interest of the future child in question. But I think it's important to talk about this. And I think there are many legislators who agree with that. That's what we can see in different ART regulations. And I wanted to take a moment to look through the language used in different ART regulations. Many ART regulations do touch on the best interest principle, which means that the best interest principle indeed could be applied to the intended child, and the welfare of children who might exist as a result of infertility treatments is a key ethical consideration in these regulations. In many countries, legislation works with this principle. However, the emphasis placed upon it differs. So in some jurisdictions, the interest of the child who could be born out of the procedure are paramount. For example, South Australia. Then we have given priority, as you can see in Canada. Then we have legislations where child interests are said to require proper consideration, or in some cases that treatment should not be provided unless account has been taken of the welfare of any child. So we can see that the best interest principle is present in these regulations. However, after studying the text of these regulations, I think it's important to highlight that it is a very surface level, because most of these regulations are still very much adult-centric. So they are talking about the reproductive rights of the parents and not necessarily in depth about the best interest of the child is not in the forefront. How the courts have dealt with these cases can be seen from the case law. And again, the case law is very rich when it comes to surrogacy, but much less so when it comes to other cases of artificial reproductive technologies and the best interest of the child. But just a few cases to mention. I wanted to highlight, of course, the Baby M case that we always talk about when it comes to surrogacy, which was a case, one of the first legal battles in the United States, which involved a surrogacy agreement that was later contested by the surrogate mother who sought to keep the child. And the New Jersey Supreme Court ruled that the surrogacy contract was invalid, but decided that the custody was to be based on the best interest of the child. The child should remain with the biological father, and the mother, the biological mother, the surrogate mother, would have visitation rights. And then we have a case from the UK in which the United Kingdom High Court had to determine the parentage of a child born through surrogacy after the commissioning parents separated before the child's birth. And again, the court's decision was supported by the best interests principle here as well. Then a very interesting case was Pratton versus British Columbia. In this case, Olivia Pratton brought a case in front of the court, and she sought a declaration stating that British Columbia's Adoption Act was unconstitutional for failing to provide donor-conceived persons the same rights to know their biological origins as those available to adopted persons. In the end, she was ultimately unsuccessful in her appeal, but the case raised very significant questions about the rights of donor-conceived children to access information about their genetic heritage. And then many other cases that I could highlight here. Maybe the last one, just a very brief moment of mentioning, worth mentioning, is that this case involved a dispute concerning parental responsibilities and contact rights for a child born by IVF. And again, the court's deliberations included the best interest of the child. Now, as I mentioned, there are so many different areas that we could touch on. So just two areas that I would briefly like to mention. The right to health, because as I mentioned, Alexandra talked about a very significant topic when we talk about ART and the rights of the child. But another topic, I think, is the right to health. Millions of healthy children have been born via assisted reproductive technologies, and including more than 6 million children born via IVF since the technology was developed in the 1970s. And without ART, of course, these children would not have been born. So that's, of course, something we have to mention. Nonetheless, ART carries significant risk to fetal health and thus to the health of the born child. So some recent research indicates that in vitro environment stresses the embryo, which then can have an effect on the development of that fetus. Now, of course, while the UNCRC does not mention the rights of the child from conception, but leaves that question kind of open, I think it's significant to mention General Comment number 13, which discusses the care before, during, and after pregnancy, and says that this time is very important from a development perspective of the child. So I think from this wording, it is clear that the intent behind it is to ensure not only that every child has the right to health or the maximum attainable level of health, but also confers this duty on the states and then extended it to parents and to third parties such as IVF clinics to ensure prospectively the health and development of the embryo and the fetus. And of course, there are so many different issues that I could mention here, you know, the prenatal screening, for example, and how it affects what we view as healthy or normal, how it affects disability and discrimination, that parents choose to terminate pregnancies that are deemed unhealthy. Many things that are connected to the right to health that we could explore here. Of course, we have to mention that the ability to detect genetic conditions early in pregnancy gives parents a choice, empowers them with a choice to decide. On the other hand, however, I think it carries the risk of reinforcing societal prejudices against disabilities. So I think that is very important to mention. And then, because we are nearing to the end, I'm just going to speed up here and just for a second mention, especially because that question popped up after the first panel, the right not to be sold or trafficked. Transfer of genetic material, and in the case of surrogacy, transfer of a child, may amount to the sale and the trafficking of children in some circumstances. For example, when it comes to a surrogate living in one country is paid at a commercial rate for a surrogacy, then the arrangement could be a form of trafficking. Article 35 of the UNCRC provides what is child trafficking, and then that is also supported by the optional protocol on the sale of children, child prostitution, and child pornography. And the optional protocol directs states to criminalize any activity falling within this definition. So in addition to this protocol, of course, I maybe also wanted to highlight or mention the UN Special Rapporteur on the sale and sexual exploitation of children, who mentions or who talks about how commercial surrogacy can be viewed as child trafficking, and she also recommends that states should create safeguards to prevent the sale of children, which should include either the prohibition of commercial surrogacy or a very strict regulation of surrogacy at all. So, in conclusion, as we navigate the complex terrain of assisted reproductive technologies and surrogacy, I think it is very important to anchor our journey and our commitment to the rights and the welfare and the well-being of children, because the very rapid advancements of these technologies, of course, present us with unprecedented ethical challenges. And I think we stand at a pivotal moment because more and more legislations, more and more policies are being born due to these developments, medical developments. So I think it is important for us to advocate for a child-centric approach, to advocate for the best interest of the child to be viewed at the forefront of these regulations and policies. And I don't think this is an option that we have or an opportunity that we have, but I think it is a moral imperative. So as we contemplate the future of ART and of surrogacy, I would like to remember the words of Kofi Annan, who said that there can be no keener revelation of a society's soul than the way in which it treats its children. So I think that these words serve as a very powerful reminder that the true measure of our progress is not found in the sophistication of our technologies, but in the depth of our compassion and in the strength of our commitments to families and to safeguarding the rights of our most vulnerable children. So that's it from me. Thank you so much for your attention, and thank you for having me.